This is one of those interesting cases which I suspect might be decided differently if it were brought in the current day and age. The story began with two 13-year-old boys after a maths class at school. One of them was carrying his school bag slung over his back, which was apparently against a school rule. The other engaged in what was described as horseplay by grabbing the bag and pulling. Unfortunately, this had the effect of causing the first boy to fall and become injured. The question for the court was whether this was unlawful assault or whether it was the normal cut and thrust of daily life and not a tort at all. Lord Justice Croom Johnson, writing for the court, said, "Although we are all entitled to protection from physical molestation, we live in a crowded world in which people must be considered as taking on themselves some risk of injury, where it occurs, from the acts of others, which are not in themselves unlawful." In other words, some physical contact, even without permission, falls short of being battery. But this leaves everyone in a degree of uncertainty, doesn't it? At what point does touching become battery? The court's answer was not altogether satisfactory. They said that touching must be proved to be a hostile touching. And that still leaves unanswered the question, when is a touching to be called hostile? Hostility cannot be equated with ill will or malevolence. It cannot be governed by the obvious intention shown in acts like punching, stabbing, or shooting. It cannot be solely governed by an expressed intention, although that may be strong evidence. But the element of hostility, in the sense in which it is now to be considered, must be a question of fact for the tribunal of fact. So when there is unwelcome physical contact, for it to be battery, the plaintiff will have to show some form of hostility. Hostility is not really defined, and it must be proven by the plaintiff on the facts. This is a hard call because hostility is essentially a state of mind, and it can be tough to demonstrate someone else's state of mind. What this case mostly does is to provide further illustration of the difficulty of drawing the line between normal social touching and assault, especially in a world where the boundaries of what is acceptable change over time.